you need to apply that hypothetical to this rule, both this rule to that hypothetical. A person domiciled in a country may also be sued if he is one of a number of defendants in the courts for the place where any one of them is domiciled. And here is the question again. So A is the passenger. Who do you want to sue and where? So you want to sue who?
F and B.
F and B. Both of them. Where?
Suppose you first word it.
Under this provision, right? Where he is one of a number of defendants in the courts for the place where any one of them is domiciled. France or? So this is in France or in Italy, depending on. So when you deal with jurisdictional statutes, this is the kind of thing that you would expect. Okay. I have a table showing jurisdictional distinctions in the rules of jurisdiction between the United States and the European Union. And I'm sure you've heard of tag jurisdiction. I don't know if you've advanced in your. The Europeans do not like that idea. They don't serve some process at the airport and claim jurisdiction over you. They don't do that. In the United States, if you're served at the airport, the court may have jurisdiction. The kind of joinder that we talked about earlier, the example that I gave you, in the United States, no, you cannot do that. You cannot bring in another defendant by joining. So there are variations in jurisdictional statutes and laws across jurisdictions. You would have to pay attention to those things. So before we conclude this section, and then as I said, it's just a way of, I don't expect you to, have a comprehensive understanding of jurisdictional complexities in the European Union, in the United States, and other places. This is just to show the complexities so that we actually focus on international arbitration and say that we can avoid all of those problems. Even after jurisdiction has been established, even after jurisdiction has been fairly established, there are diverse trial concepts in the common law and the civil law. So if you're trained in China, now it doesn't concern you because you're studying both common law and civil law. But other people who study in other law schools, they only study civil law or Chinese legal system. You are a lawyer, licensed perfectly, no problem, sharp, studied. But if you go to court in London, the way they do things is completely different. Completely different. And you might find yourself puzzled, surprised, and they may not understand. I'll give you an example. I was involved in an arbitral proceeding in London last November. I was representing a party, a state-owned enterprise. And there were 5 arbitrators, all UK arbitrators. And this was called GAFTA, Grain and Feed Arbitration Center in London. And I was cross-examining the CEO of the company that we sued. The CEO testified under cross-examination. He admitted certain things. And then there was another witness that they presented. And there was a witness statement submitted already, and I had read the witness statement. This guy was the CFO of the company, the chief financial officer. And I only asked him one question. And I asked him, what is the basis of your knowledge? And he said, I was informed by the CEO. And I said, I have no further questions. All the 5 arbitrators were so, this guy actually came from Geneva to testify, and you ask him only one question? They were highly surprised. So in the United States, when they train you how to cross-examine a witness, if the basis of that person's knowledge is completely is from another witness who actually has been discredited, there's no point in talking to this other guy, right? In the UK, all 5 of them expected me to go through each one of those questions over again with that individual. These are different conceptions of how you present evidence, right? So they almost seemed annoyed that I didn't ask him any questions. And the judges asked me, is that it? And I said, yes, that is it. And then, of course, the other party did not have the opportunity to talk to him, because ordinarily, when you ask a witness recross or redirect questions, it has to be based on testimony that they provided. Having not provided any testimony, they had nothing to say to him. So he was excused in less than 1 minute. If you do that at times, you could actually end up annoying judges, and annoying judges is really not a very good thing. But in any case, that was we prevailed in that action. But that was a strategy. It was a risky strategy, but that's what I did. I've realized afterwards that they may hold completely different conceptions of what testimony is all about. If you do that in the United States, absolutely acceptable. In other places, it may not be. I don't know how they treat that condition, that kind of situation in China. But every time that you appear before a jurisdiction where you're not trained in or you do not know the intricacies of their trial concepts, it could be complicated. You may even be misunderstood. Now, I'm not going to tell you that all these problems are avoided in international arbitration, but it's worse in court litigation because it's always one-sided. You are in someone else's jurisdiction, or they are in your jurisdiction. So that is what I wanted to say. So if you look at the adversarial system, it's accusatorial, as they say, and record is developed by the parties. There is a pre-trial and there is a trial. The judge takes absolutely no part in developing the record, right? In common law, if you tell common law people that the judge actually can call her own witness, they would be really surprised. Like a judge calling her own witness, it's completely unheard of. In civil law legal tradition, judges do that all the time. They can ask for expert testimony, they can ask for fact testimony, that's not a problem. So the trial concepts are completely different. In civil law, they call it's investigative or inquisitorial. The judge is eminently involved from start to finish, developing the record, collecting things. The adversarial trial is like the judge is neutral and they just want to declare the winner. There is an amalgamation of these systems in international arbitration that would be studied. But if you're trained in one system but appearing before a judge in another system, you could be surprised in a wide variety of ways. Let me just cite one more example and end this section of the discussion. If you are in a classic civil law legal tradition, you are not supposed to talk to a witness before you present the witness in court. How is it in China? Can you prepare a witness before you present the witness in court? Can you talk to her? Can you prepare her? Can you write the affidavit for her? Or are you not supposed to talk to her before she's presented in court? In certain jurisdictions, I know, in France, for instance, if you do that, you would be disbarred. You're not supposed to talk to witnesses because the judge should ask her without preparation because they think that you're actually manipulating evidence. In the United States, if you fail to do that, you may be disbarred because it's considered malpractice. You have to prepare the witness properly. There are certain things that you cannot do. You cannot tell them to lie, but it is important that you actually prepare the witness before you present them in court. So these are completely different concepts, right? In fact, they're opposite concepts. So that's why you have to be extremely careful when you litigate cases or have someone litigate on your behalf in various jurisdictions that you're not familiar with. Now, does international arbitration avoid all these different conceptions of trial? Does it take it outside of the arbitrators? No, it doesn't. But it ameliorates it, it minimizes it in such a way that you can select judges and arbitrators from different jurisdictions. And they in many cases, they have appreciation of different traditions. They try to work with you. And it's an amalgamation of different traditions. And we'll study about that as well. Okay? So that is a very brief introduction of the challenges of transnational litigation and sort of justification for our study of international commercial arbitration. If you don't have any questions on this, we can proceed with our introduction of the basic principles of international commercial arbitration. Of course, as of next class, you will come prepared after I have assigned you readings from the Gary Horn textbook. And I would also ask you to always bring a copy of the New York Convention with you. And I recommend that you bring a hard copy of the New York Convention because we'll be referring to the New York Convention in class repeatedly. We'll be studying every provision of that convention. Okay, so there's another PowerPoint that I'd like to pull first. Give me a second. Part one starts with a very basic question of what's international arbitration. Objectives of international commercial arbitration are legal framework, the agreements, procedures, And part 2 is not something that we're going to be studying in detail in this class. That is on investor state. I think there's an independent course for that. Okay, here's a definition. An international arbitration is a process by which parties consensually submit a dispute to a non-governmental decision maker selected by or for the parties to render a binding decision resolving the dispute in accordance with adjudicatory procedures, affording the parties an opportunity to be heard. So the key there is a non-governmental decision maker. That is as opposed to what? A non-governmental decision maker is as opposed to a governmental decision maker. What is a governmental decision maker? Courts, right? The courts are governmental decision makers. So the decision itself is not made by a court. It's by private individuals. Arbitration, you select the individuals. Then you might wonder, so what is the value of a decision made by non-governmental people outside of the court system, private individuals? What is the use of that? How does that work? That is really the question that we'll be addressing in this course. Yes, there is value in having an award from non-governmental decision makers, and the main reason why it is valuable is because eventually the governmental decision makers, the courts, will give it effect, would enforce it. How? We will study how. When? We will study when. Under what circumstances? We will study under what circumstances. The first thing that comes to mind is, aren't these private individuals doing what courts are supposed to do? Adjudicate controversy. Why do we even need them? In domestic arbitration, there's always a need for a variety of reasons, the economic expediency, cost, whatever it is. In international arbitration, people tell you about all those things. It's cheaper, expedient, things like that. In my opinion, it's not all that. It is primarily because we'll be able to avoid the kinds of jurisdictional intricacies that we just talked about. A model clause. Ordinarily, when parties agree to an arbitration, they would say something like this. All disputes, claims, controversies, and disagreements relating to this agreement shall be finally resolved by arbitration. Under the rules, the seat of arbitration shall be here, the language shall be such and such. This is what you are expected to do in an arbitration. It's usually inserted into an underlying contract. You almost never independently conclude an arbitration agreement. An arbitration agreement without an underlying agreement is worthless, right? It's about disputes arising out of some other contract. Could be for the sale of goods, could be for building a house, it could be anything, right? Once you have that arbitration main contract, it's usually like this. No. This should be B. So the main contract is A. We will be referring to it. A is for the sale of goods. And the other contract is this clause that says all disputes, claims, controversies relating to this agreement. It's talking about this agreement, the main contract. So this is the arbitration agreement. It is usually Article 25 of the main contract. It says all controversies relating to this shall be arbitrated. Or it could be independent. You can have a contract here, and then subsequently the parties agree, oh, in case of controversy, instead of going to court, because that's the default dispute settlement mechanism, right? Instead of going to court, why don't we agree to arbitrate? So this agreement independently refers to the other agreement. And when it does so, it says all controversies, claims, and things like that shall be, and you include all the selection of law and how we're going to do it, and all that is included in there. So this is a good sample of what it looks like. What isn't international arbitration? It's important to know what isn't. Mediation, conciliation, expert determination, forum selection agreements. I'm sure in China mediation is, I hear it's very common. The difference between arbitration and mediation is at the end of the process you don't have anything that is binding in the sense of something that would be enforceable as a court judgment. In arbitration, at the very end of the process, you get an award. That's the name of the thing. It's a judgment. That award is enforceable as if it were some kind of court judgment. In mediation, at the end of the process, what you have is a contract, right? You mediate, oh, there's a dispute. You go to mediation. Mediators try to resolve the problem, and you end up with what? You agree on A, B, C, D, E, F, G, right? And if you want to enforce that, and someone says, no, I'm not going to be bound by A or B, that's going to be what? A mere breach of contract. But in arbitration, if he says no, the next step is his house is attached and sold. It's enforced as if it were some kind of court judgment. So mediation in that sense is different from conciliation. Has its own processes. Different processes are given different names, but of course the main distinction there is also that you don't have a binding enforceable award at the very end of that process. Expert determination, forum selection agreements. In your civil procedure class, I'm sure I don't know if you've gotten to that point. Have you studied forum selection? Zapata v. Bremen, those kinds of cases. Forum selection simply is like Sheriff v. Alberto Colbert. You could be in Paris and you could be in London or in Beijing and say in an agreement that if a controversy arises, we shall adjudicate in Washington, D.C. Consent? It's consent-based. So if then one of the parties goes to Washington, the other party cannot say, oh, court in Washington does not have jurisdiction. Why? Because you agreed to a forum selection agreement. That's expressing a consent. That is different from arbitration, because arbitration is a non-governmental decision maker that would eventually produce an award, enforceable some way. We'll study about how to do it. But a forum selection clause is selecting a particular court to adjudicate, not arbitrate, adjudicate the cases. Yes. So it is different from arbitration in that sense. We're talking about court selection. Forum selection is selecting the forum, the court, where you litigate the case, not arbitrate. In here, one calls it a natural dispute resolution forum, a neutral, and versus local courts. That is the objectives of international arbitration. If you are Chinese and you go to a court in Washington, the presumption is that the court in Washington if you are suing someone who lives there, who resides there, is a citizen there, may be biased in favor of that arbitration. Is it always true? May not always be true, but the presumption is that it is that court bias. And in commercial arbitration, some very complex matters could be arbitrated, right? Patent issues, things like that, judges may not be familiar with the intricacies of those. So if you have an arbitral tribunal, you can select people who have the expertise in that particular field. And then enforceable agreements and awards. This is something that we talked about earlier, jurisdictional uncertainties, party autonomy and procedural flexibility. Domestic courts are bound by specific procedural rules. They have very strict rules. They have to conduct their hearings according to those rules. In arbitration, you can amend those. You can be flexible. There is that flexibility and autonomy. The parties can agree as to how they want to conduct the hearings, and all types of flexibility is built into that system. Cost and speed, I'm not sure about that, but sometimes it could be cheaper to do arbitration if you plan it very well. Sometimes it could be more expensive than court litigation, depends on the nature of the case and how you structure it. And there is the confidentiality or privacy. In public litigation in court, most court litigations are public. If you have trade secrets, other things that you don't want people to know, arbitration might be a way to go because you can make it confidential. Sometimes confidentiality is not necessarily a good thing. One party might want publicity, another one might say confidentiality, but that possibility exists here in any case. Case law growth, I need not tell you because China is CTAC in 20 years ago, they only had I don't know how many cases, but now they're probably the first in the world. So we can begin legal framework, and that is important. Let's take a break of about 5 minutes. Is it 5 or 10? 10 minutes. Okay. Okay. Let's take a 10-minute break and come and finish this. Okay.